Good morning, everybody. My name is Carissa Davis. I'm one of the attorneys here at Sherman and Howard. Here joining me is Brooke Khaleesi, another attorney in our Labor and Employment Department. We want to thank you all for joining us via webinar. I know that this coronavirus outbreak is, canceling a lot of events and things are changing very quickly, so we appreciate your patience in joining us via webinar. Today we are talking about the Colorado Overtime and Minimum Pay Standards Order, the new COMPS Order number 36. It supersedes previous wage orders, wage order number 35, and even though it has a different name, it does supersede that previous order. And with it, it brings across some new effects, new changes. Some of the greatest changes, the most significant changes, are an expansion in coverage. The definition of employer is broadened. Industries that were previously uncovered by Colorado minimum wage orders are now covered under the COMPS order and therefore need to come into compliance. There's also a new salary threshold in terms of some exemptions from overtime. So we'll discuss that as well. An additional minimum wage increase, and then there's some modest adjustments in with the COMPS order that we believe actually bring about some very significant changes. So we'll discuss those in turn. And if you have your voice on audio, we ask that you mute your voice. That way, we don't get any feedback through this feed. So with that, I'll throw it over to Brooke to explain the expansion and coverage.
Good morning, everyone. I echo Carissa's thanks for joining us via webinar this morning. I'd like to start out by discussing the expanded coverage of the COMPS order, which I think almost everyone would agree is the most significant and frankly startling change between minimum wage order 35 and the COMPS order number 36. Those of us who've been practicing in labor and employment have been complaining for years about how unspecific and undefined the coverage of the previous minimum wage orders has been. We weren't exactly anticipating this dramatic a change, although we were certainly hoping that we would get some more clarification. And the department certainly chose to do that by essentially flipping how this state regulation applies, from limiting it to certain industries to essentially making it broadly applicable to almost all employers in the state of Colorado. So previously under Wage Order 35, only retail and service, food and beverage, commercial support service, and health and medical were covered. It was very unclear exactly what the definitions of those particular industries were, but at least a good many Colorado employers knew that they weren't covered by the state regulation. Under COMPS Order number 36, all employers and employees are presumptively covered unless they fall within a very specific exemption. We'll talk a little bit more about the exemptions in detail, but in summary, we have the administrative, executive, and professional exemptions that we're familiar with under the FLSA. Outside salespersons, owners, and proprietors are exempted. Interstate transportation, something that also mirrors federal wage and hour law. We also have some minimal exemptions for in-resident workers, although I want to point out that the state has significantly narrowed the in-residence worker exemption. Under the previous wage orders, in-home workers such as housekeepers or live-in nannies were exempted for most of the provisions of the wage order. Those two classifications have been removed. And so they are now presumptively covered under the wage order for both overtime, minimum wage, as well as the meal and break provisions that we're going to discuss a little bit later on. Casual babysitters, property managers, certain student residence workers, field staff, and some seasonal outdoor folks are still exempt under this exemption. But the most significant change there was the removal of housekeepers and live-in nannies. Then finally, elected officials and their staff, volunteers in work study, and agricultural employees are also exempted from the wage order, or from the COMPS order. We also have a slight change in the definition of employer under state law. The state of Colorado has now adopted the FLSA's definition of employer. And that includes an employer includes any person acting directly or indirectly in the interest of an employer in relation to an employee. So on the one hand, we now have a definition that matches what we're used to under the FLSA. But the most significant change that this creates for Colorado employers is that there is now presumptively individual liability for wage and hour violations under the COMPS order. There has been individual liability under the FLSA, but we had a Supreme Court decision, Leonard versus Morris, in the state of Colorado that held that the previous minimum wage orders did not establish individual liability. Given this new definition, it looks like we probably will have individual liability now in the state of Colorado. So what does that mean? That means that you could very well see wage and hour lawsuits being brought against you as a company, and also naming certain individuals within the organization. It tends to be very high-ranking executives or HR folks, for example, or if there's someone very wealthy associated with your organization, those individuals. And the plaintiff will attempt to establish that those individuals are somehow directly responsible for the wage and hour violations. In a lot of cases, the individuals drop out of the lawsuit at some point, but the reality is that we could have individuals who are now stuck as defendants in lawsuits under the Colorado regulation, at least at the outset of litigation. So we'll have to see how that plays out and whether that really turns out to be true, but that's what we've seen under the FLSA with respect to individual liability. The new COMPS order also specifically includes, adopts, and incorporates the FLSA and its regulations. Now, this is another important change and one that's undefined in terms of exactly how it's going to play out. On the one hand, the state of Colorado historically, in most cases, has relied on the FLSA and its interpreting decisions and deciding how cases should come out under Colorado state law. The flip side of that, though, is that the wage orders and the COMPS order do not mirror the FLSA word for word, even on topics that overlap. So presumably the incorporation of the FLSA and its regulations would mean that we could still rely on federal law, federal court decisions, federal regulations in interpreting the provisions of the COMPS order. But given the fact that the language is not identical, we'll have to see if that's really how these cases play out as cases are brought under the COMPS order. So that's a little bit on the expanded coverage. I'm going to turn it over to Carissa now to talk a little bit about how joint employment is going to work.
All right, so as Brooke just mentioned, there is some interplay between the COMPS order and the FLSA. So when I'm talking about joint employer status here, this really concerns the FLSA, but we want to note it as potentially an important point here in the state of Colorado. The Department of Labor just enacted a new rule for determining joint employer status. And why is joint employer status important? It may mean that one employer who employs some employees may be joint and severally liable with another employer who shares the benefits of those employees, but determining who is the joint employer is different by these tests. So under the new Department of Labor test, it's a 4-factor test that considers whether a potential joint employer may hire or fire individual employees, supervise and control to a substantial degree the employee's work schedule or employment conditions, to determine the employee's rate and method of payment, and maintain the employee's records. Now, none of these factors are dispositive, and additional factors may be considered given the circumstances, although the maintenance of employee records alone will be insufficient to establish joint employer status. Critically, the reservation of the right to control the worker's schedules or conditions alone will not establish joint employer status. The employer must actually exert control over the worker. So this test has been adopted in effort to address a jurisdictional split across the United States and try to simplify the test for joint employer status. However, it's important to note that Colorado, in addition to 17 other states, have sued the Department of Labor over this definition of joint employer status. There are a myriad of arguments presented by these states, but they essentially come down to allegations that the joint employer status is not protective enough of employees. We don't really know how this will play out, but we want to note this as an issue where you should stay tuned to the definition of joint employer and the effects in Colorado. And by way of comparison, I included the National Labor Relations Board definition of joint employer, which is clearly more simple and more streamlined than the Department of Labor definition. Under the NLRB, the business must possess and exercise substantial direct and immediate control over one or more of the essential terms and conditions of employment or another employer's employees. So with that definition, it seems a bit more simple, but because we're talking about the FLSA here and the COMPS order, the Department of Labor standard for joint employer should be considered. So one of the most important topics that's covered under the COMPS order is overtime. What is overtime? I think most employers are familiar with this concept. It means that an employee who is not exempt from receiving overtime is entitled to receive time and a half, the regular rate of pay, for all hours worked in excess of 40 hours per week or 12 hours per day, or if a 12-hour shift spans over the course of technically 2 days, that employee would still be entitled to overtime pay. Just because somebody earns a salary doesn't mean that they are exempt from receiving overtime. I have to say that that's probably one of the most common misconceptions I hear regarding wage and hour law. So salaries, if an employee is paid via salary, but they are not exempt under the order, they can still be entitled to receive overtime compensation, and there are ways to calculate the regular rate of pay for that employee when they are paid that salary. All right, so here's where it gets confusing. In order to be exempt from overtime pay, the employee must perform exempt duties and earn a sufficient salary, only for some exemptions. So as Brooke mentioned earlier, there are some similar exemptions under the COMPS order and under the Fair Labor Standards Act. Executive, administrative, and professional are the classic categories of exemptions that we discuss under the FLSA and the previous wage orders. But there are some differences here, and I want to note those quickly. So under the executive order, in addition to the requirements that are set under the, the executive exemptions, in addition to the requirements that are set under the FLSA, under the COMPS order, that employee must spend a minimum of 50% of the work week in duties directly related to supervision. So this executive and supervisor exemption under the COMPS order differs from the FLSA in that aspect. Under the administrative exemption, there's an additional requirement under the state COMPS order that the individual must directly serve the executive. That's something that we haven't seen with the FLSA and something that's important to note under this state order. Notably, under the professional exemption, under the COMPS order, we do not have a creative professional exemption, but still much of the language is similar amongst these three exemptions. We also have computer-related occupations and outside sales. Under the COMPS order, there are some exemptions that do not require a salary threshold in order to be applicable. Certain salespersons and mechanics, and those salespersons, we're talking the sale of boats and trucks, etc., commission sales, ski industry, medical transportation, this 8 and 80 rule, and there is a temporary exception for nonprofit employers, where the salary threshold does not take effect until January 1, 2021 for nonprofit employers with a total gross revenue under $50 million and for-profit employers with an annual gross revenue under $1 million. So as I mentioned, these exempt duties, many of them except for the ones that are noted under the salary threshold not applicable, require exempt duties to be performed and a sufficient salary to be earned. So this salary threshold is one of the newest additions under the COMPS order. As you can see, under Wage Order 35, there was no there was no salary threshold in order for an employee to be exempt from overtime. Here, the salary threshold differs by each year. The salary threshold takes effect on July 2020 at $35,568. As noted, there is that slight exception for the nonprofit employers and for-profit employers that I mentioned earlier. Under 2021, the salary threshold increases to $40,500. 2022, it bumps up to $45,000. 2023 up to $50,000, and 2024 up to $55,000. So you can see that there's a fairly steep increase in terms of what the salary threshold is set at. And after 2024, in subsequent years, that salary threshold will be adjusted by the same consumer price index that's utilized to set the Colorado minimum wage. So if you compare that COMPS order salary threshold with the federal FLSA salary threshold at $35,568, you can see there's a pretty significant difference and a pretty steep increase in the upcoming years.
The COMPS order also slightly adds to the definition of time work that we saw under the previous minimum wage orders. And the examples that are included in the new definition are worth discussing, as they're clearly aimed at certain types of activities that the state of Colorado wants to make sure are now specifically addressed as time worked by employers. So the basic time work definition remains with the employees performing labor or services for the benefit of an employer, including all the time he or she is suffered or permitted to work, whether or not required to do so. So that's what we're used to in terms of a definition of time worked. And again, it makes clear that it's not simply what work the employer is specifically directing, but if the employer is allowing an employee to work without stopping that employee from working, that is time work that needs to be accounted for. So that's not a change from the previous orders. However, there are some examples now of activities that are specifically included in the definition of time worked to the extent that they take more than 1 minute to accomplish. One of those is the donning and doffing of work gear. Some of you may have had cases or situations, probably under the FLSA, where there's a dispute over whether or not donning and doffing specialized gear in the before a shift and after a shift is work time that has to be compensated. The state of Colorado now says that activity, if it exceeds 1 minute, does in fact qualify as time worked and must be compensated. Receiving or sharing work-related information is also time worked if it exceeds 1 minute. This seems directed towards after-hours activities such as reading emails, sending emails, listening to voice messages. And these are activities that, for many employees, are necessary parts of their job. They're also activities that can be very difficult to track in terms of keeping track of hours worked. So if you have non-exempt employees who do these kinds of activities after hours, please make sure that you look at your policies, look at your procedures, and account for that time in some manner. A couple of ways of dealing with it. One, establishing a time worked clock in, clock out, or time recording system for employees to use after hours to make sure that these kinds of activities are accounted for. The alternative is to, if feasible for your business, put very strong policies in place limiting these types of activities after hours so that you don't have to worry about there being time work that's going uncompensated. The definition of time work now also includes security or safety screening that exceeds 1 minute. There have been several different scenarios, cases recently, one out of the 10th Circuit, out of California, a case involving Apple. I saw one just the other day, I think it was Costco or it could have been Sam's Club, one of the two, where employees have to go through security screening either on their way into shift or on their way out of shift. And the past disputes have been whether or not that is work time that must be compensated. Under the new COMPS order, if it exceeds 1 minute, security and safety screening is time worked and must be compensated by the employer. Presumably, to the extent that there are any types of medical monitoring that goes on in the wake of the current situation with coronavirus, I've heard rumblings of employers wanting to do things like take the temperature of an employee before they come into shift. Notwithstanding whether that's a wise idea from a medical standpoint or an ADA standpoint, any of those kinds of activities in the current emergency situation presumably would be time worked as well under the same kind of analysis. So if you're considering any of those kind of measures, it'd be a good idea to have a chat with your attorney. Number one, to make sure that those are legitimate things to do. Number two, to make sure that they're compensated properly if they need to be. And then the last two examples under the definition of time worked are ones that existed under the minimum wage order as well. Employees who are remaining at a place of employment awaiting a decision on whether or not they need to go to work. So a couple of examples. If a production line goes down and the employees are waiting around for it to come back up, that is time worked. If there's a building emergency and the building is evacuated and employees are waiting around, that would presumably be time worked as well. And then finally, cleanup or other off-the-clock work, which has always been an interesting choice of words since off-the-clock work is not permitted, has never been permitted, and obviously needs to be compensated. So the critical ones to keep in mind if they're applicable to your business are the donning and doffing, the after-hours emails, those types of things, and the security and the screening. Those are the new ones that are added to this definition that presumably will be a focus of the agency's enforcement efforts when those efforts get ramped up. COMPS order also creates a slight change with how rest breaks are handled under Colorado state law. Rest breaks have long been a component of the minimum wage orders, excuse me, and employers have been required to provide them. And on your handouts, thanks, you can see a chart that kind of breaks down how many rest periods are required based on the hours worked. These are 10-minute breaks. They are required to be compensated. There is an exception for a limited time period if by written agreement. The employer and the employee can agree to 2 5-minute breaks rather than 1 10-minute break. But the 5 minutes has to be sufficient for the employee to do certain necessary activities, such as visit the restroom. Also, there are some limits. Some of the limits are relaxed with respect to collective bargaining agreements, but there are still some standards that are expected to be met even in the collective bargaining agreement. So employees covered by a CBA need not receive 10-minute rest breaks every 4 hours. If on average the rest breaks over the workday amount to at least 10 minutes per 4 hours worked, and at least 5 minutes of rest is given every 4 hours worked. So those are the general parameters that apply to employees under a CBA. Now, from an enforcement standpoint, the change with respect to rest breaks is how it's viewed in terms of violation. The new COMPS order makes it clear that because a rest break, it must be compensated. If an employer does not provide that rest break to an employee, it is the equivalent of that employee working 10 minutes off the clock. So the requirement of the COMPS order is that if an employee does not receive his or her break, he or she is entitled to an extra 10 minutes of compensation for that day. What this does is it presumably sets up rest break violations to essentially be claims for unpaid wages, subject to wage demand, lawsuit, and the like that we see with other claims of failure to pay wages. So we'll have to see if that's really how it plays out, but that's what the new language suggests is going to be the enforcement mechanism for violations of rest breaks.
All right, so I'm going to talk about credits towards wages, and this concept can kind of be difficult to wrap your mind around, so I'll kind of explain what credits are. Employees are entitled to wages for their hours worked, but how wages are paid doesn't necessarily have to come in the form of just monetary compensation. With some employers can pay parts of the employee's wages through meals or the provision of lodging or tips. So what we're talking about here is the meal credit, and actually under the COMPS Order 36 compared to Wage Order 35, the requirements for meal credits make a bit more sense and are a bit more preferable to the employer. So previously under Wage Order 35, the credit would only be permitted after the employee consumed the meal, regardless of if the employer had already purchased and provided that meal. So under the COMPS Order 36, the employer provides the meal, the credit may be deducted. Makes a bit more sense in that aspect. The amount of meal credit, of course, must be reasonable. It will be measured by the reasonable cost or the fair market value. However, you cannot include profit in terms of measuring how much the meal credit should be applied. And of course, as is the same under COMPS Order 36 as was under 35, acceptance must be voluntary of the meal. Commonly, a lodging credit may be applied in addition to a meal credit. So under Wage Order 35, the lodging credit was permitted so long as it was for the primary benefit of the employer or the employee, and there need not be a written agreement. However, under Wage Order 36, there's a new requirement that the credit should be recorded in a written agreement that states the fact and the amount of the credit. This doesn't need to be a formal lease, but there obviously needs to be some sort of written agreement. As with the meal credit, it needs to be voluntary. However, under the new COMPS Order 36, it needs to be for the primary benefit of the employee. Now, the amount of the lodging credit is set forth in 3 different calculations, and the employer must pick the smallest of the calculations. The lodging credit can amount to the employer's actual cost, the fair market value of the lodging, or $25 a week in a shared residence or dorm or hotel, or $100 a week for a private apartment or a house. It's very important to notice that the COMPS order requires the employer to pick the smallest of the calculation. So even if it costs more to the employer to furnish the residence, say more than $25 a week in a shared residence, the employer is only permitted to deduct that $25 a week for that shared residence. It does not matter that the employer incurs some loss at providing that lodging.
And just another quick follow-up word on the lodging credit. Obviously, most employers probably don't have a lodging credit issue with their workforces. If you do, the new state test more or less mirrors the FLSA test. And through practice, it's proven that that test is a little difficult to administer because the whole concept of whether housing is for the benefit of the employer or the employee, let's just say people could have very different opinions on that. So if you do have lodging credit as part of your compensation scheme, it's worth taking a look at it, making sure you're comfortable with the application of the tests to your specific situation, because it's not the easiest test to apply. Moving on quickly to uniforms, the COMPS order makes a slight change to the requirement for uniforms under state law. In the past, employers have been permitted to require deposits for security purposes, destruction purposes, and the like. Those are no longer allowed under the new COMPS order. If the uniform is a condition of employment, the employer must pay for the purchase, the maintenance, and the cleaning. The only exception is if, for example, the uniform is a red shirt and black pants, and the employee can purchase those of any style from any location that they want and wear those to work. In that particular situation, the employer probably would not be required to pay for it. Employers are not permitted to deduct the ordinary wear and tear on a uniform from the employee's pay. Even if there's an agreement to that effect, that's no longer permitted under the COMPS order. So I want to spend a little bit of time now talking about the wage poster and distribution issues under the new COMPS order because they're significant, and I think this could require some changes in your process as an employer. So under Wage Order 35, the employer was required to put the poster in a common area if the worksite allowed for it, or to make it available upon request. So it was a fairly simple posting requirement. Under the COMPS order, it's more complicated, and a failure to comply with the posting requirements means that as an employer, you lose the ability to take exemptions or credits as to an individual employee. Not necessarily the industry-wide exceptions, those are still permitted, but any individual employee exemptions are lost to you if you don't comply with the posting requirements. So it's important to pay attention to make sure you make any adjustments to your process if you need to. So with respect to posting, if physical posting is impracticable, then the employer shall provide a copy of the poster to each employee within his or her first month of employment or each time it is requested. With respect to distribution, and this is one that might require some adjustment on your end, if you distribute a handbook of some sort to employees, whether it be electronically or in hard copy, or if you distribute some sort of manual to employees, or if you make policies available to employees, either in hard copy or, for example, if you have an intranet where you make the policies available to employees, you have to include the COMPS poster as part of those materials. And if you require that an employee sign any kind of acknowledgement related to these materials, at the same time that they do that, you must provide them with a copy of the poster, the COMPS poster, and have them sign and acknowledge receipt of that, just as you do the other policies. Now, one question that's posed by this requirement is, do you have to distribute the COMPS poster every time you send out a policy or a handbook update or something to that effect? And the COMPS order is not precisely clear on this point, but the way I read the language, whenever you update your handbook, presumably the updated handbook will include a copy of the COMPS poster. I think the language can be fairly interpreted that if you update a handbook policy or if you update a standalone policy and you are merely circulating the update to employees, you do not necessarily need to include the COMPS poster with that distribution. I think the language can be read to simply require that the COMPS poster be included in the collection of your materials and that it be treated like all others. That's the way the language reads to me. It's not specified in the COMPS order if that's what's required, but that seems to make the most sense, as it doesn't make a lot of sense to think that every time a revised policy is distributed, you have to throw the COMPS order with it, even though it may be completely unrelated to the topic of the other policy. So we'll see if we get more guidance on this or if there's a different interpretation that becomes prominent, but I think that's how the language reads at this point. It is also important to note that if you have employees who speak languages other than English, you are obligated to make sure the poster is available in those employees' language. Our understanding is that the division will be providing a Spanish version of the poster, and that an employer can contact the division to request a poster in a different language if you have employees who speak neither English nor Spanish. So that's our understanding of how that will work under the new COMPS order. So if you have employees who speak other languages, it makes a good sense to reach out to the division and get a sense of what their plans are with respect to those alternative interpretations. So we've included in your materials a copy of the COMPS poster. This is available on the division's website. Obviously, this is the document to use. You don't have to prepare something on your own, and this is the one that the department has determined complies with the COMPS order. So this can be found on the website.
All right, so we have a new minimum wage here in Colorado. Under Wage Order 35, the minimum wage was $11.10 an hour. The tipped wage is a little bit different because tip credits, and I'll explain that in a minute. Under the COMPS order, we now have a minimum wage of $12 an hour for all hours worked. Now remember that the definition of time worked or hours worked is quite expansive, so it's important to ensure that you're properly measuring that time in terms of the minimum wage. So who is entitled to the minimum wage? Anyone who's covered by this order or the FLSA minimum wage. So it's set by constitutional standard, and it may change each year. So we have $12 an hour for non-tipped employees and $8.98 an hour for tipped employees. Now, why is the tipped employee minimum wage lower than it is for non-tipped employees? That's because the COMPS order permits a tip credit. Under the Wage Order 35, we had similar tip credits. However, obviously, the amounts were lower. Under the COMPS Order 36, the cash wages of a tipped employee's wages must amount to $8.98 per hour. You can have a $3.02 tip credit that can make up the difference between that $8.98 and the $12 minimum wage per hour. However, if the tips for that tipped employee do not amount to that $3.02 and don't come up to that $12 per hour, then you as the employer, you're required to make up the difference to ensure that that employee is receiving the minimum wage. So it's important to measure that with each paycheck received by a tipped employee. And finally, before we answer some questions, Brooke is going to outline some of the important things to remember about the Fair Labor Standards Act and the interaction with the state COMPS order.
Thanks. And then kind of to wrap up, obviously this is a new regulation for all of us to get used to. Some things are very much the same, some things are different. So, we are always here as a department to help answer any questions or to interpret some of the new language so that you can make sure that you feel comfortable moving forward under the new regulation. Some things to keep in mind. I think the interaction of this new regulation with the FLSA will be interesting to watch. As I noted earlier, it appears that there's been an attempt to make the two somewhat similar and to suggest that the COMPS order will be interpreted similar to the FLSA. We'll have to see, the extent to which that is true or if there are any significant exceptions that develop. But just as a reminder that you should pay attention to the differences between state law and the FLSA and the language, and not necessarily assume that state law will be interpreted precisely as the FLSA is or that it means the same thing. And those of us in our department are certainly happy to help, weed through that if we need to. Also a reminder that state wage law prevails to the extent that it is more protective of employees. So any provision of Colorado law that is stronger or more protective than the FLSA provision will apply, and you'll need to follow the state law. And just as a reminder that if you have, employees in other states, you'll have to go through the same exercise with respect to the law in those states, and obviously make sure that you're complying with the correct provisions if you're a multi-state employer. So here in a minute, we'll turn to some of the questions that you had. One thing I want to ask you to pay attention to on a slightly different topic, although certainly touches on the concept of wage and hour. You may have heard that last night Colorado has passed some emergency provisions for paid sick leave for employees in certain industries as a result of the coronavirus emergency. We will have a blog post up hopefully today. I believe it's very close to being posted. That will outline the requirements of those paid sick leave hours. So pay attention to the blog on our website for information on that if you're not familiar already with those requirements, and that should be up later today.
Okay, so we have received quite a few questions, so we're going to go over these in turn and try to give you our best interpretation of what these questions ask. So I will read them out loud, and then Brooke and I will take turns and answer, and try to give you the best advice that we can. So our first question: if an employee is working an 8-hour shift and does not take a morning break, but wants to take a paid 20-minute break in the afternoon, would that count as taking both the morning and the afternoon break, or would you still have to pay for the morning break? So part of the rationale behind breaks is trying to ensure that employees have to take some time away from their work and are able to maintain their safety if, say, they're working in construction. So as the regulations provide, when practicable, the break should be taken in between each 4-hour work period. So if you concentrate all your breaks in one period, that kind of defeats the purpose and the intention behind the break requirements. Now, earlier, Brooke and I explained the two examples where the breaks need not be taken in accordance with the order as set forth. Let me get the order here. By written agreement, and it can only cover up to 1 year, so it would need to be ratified each year, the employer and the employee may voluntarily agree to 2 5-minute breaks as opposed to the 1 10-minute break. But that agreement will only be permitted if the working conditions are such that 5 minutes is a sufficient amount of time to allow the employee to go back and forth to the restrooms. And then there was that other collective bargaining agreement example that Brooke provided. Now, with this question, it's asking about 20-minute breaks. The employer is always permitted to provide longer breaks. The COMPS order certainly doesn't set a ceiling on how long the breaks can be provided for, but the order does show that the breaks need to be taken in those 4-hour increments. So aggregating it to the 20-minute break at the end of the day would not really effectuate the purposes of the COMPS order. All right, moving on to the second question. If an employee wants to take a longer lunch, can he add his morning break to the beginning of his lunch and his afternoon break to the end of that lunch? We will pay for the breaks, but not for the lunch. So that's correct that the lunch is unpaid, but the breaks are paid. So that interpretation is correct. But again, we run into the same issue here where the breaks are meant to, be a pause in between the work that the employee performs, particularly for safety concerns. I know that was one of the issues that the division was trying to address and received at the public hearing. So construction is the typical example I think of. But you need to look at those requirements in the actual wording of the COMPS order. It needs to be set within those 4-hour periods. Third question: if an employee does not take an uninterrupted lunch break for 30 minutes, do we have to pay for the extra 30 minutes at the end of his shift? The lunch breaks are uncompensated under the COMPS order. Only the breaks are compensated, and the employees who are covered under the order are entitled to receive a 30-minute unpaid lunch break.
And consistent with the way the law worked under the minimum wage orders, if there's any part of that 30-minute meal break that is not duty-free, it is time worked, and you have to compensate the employee for that time. Now, the COMPS order does not approach meal breaks the way rest breaks are approached in terms of the extra 10 minutes of compensation if they don't get their 10 minutes earlier, which can be read as requiring that 10 minutes even if they had, a 2-minute break. So the bottom line is the law has not changed with respect to meal breaks. If there's any part of that 30 minutes that is not duty-free, it has to be compensated as work time.
All right, here's another question. Does electronic distribution, like online access of pay stubs, meet the standard of statement distribution discussed in the law?
With respect to the COMPS order, the language is fairly simple. It simply requires that employees be provided with that information. Now, judging from the way times are changing and how much employers are moving to electronic distribution of such things, I think such distribution would be permissible. The one thing to watch out for, though, is the one place you could get in trouble is if for some reason you have an employee who does not have the ability to access that material online. Now, I think as we go further and further into the electronic age, it's likely that fewer and fewer employees have those impediments. But I think you still want to have some sort of contingency available for employees who may not be able to access that information electronically. It may be accessed within the workplace, although I think it's not clear that the state of Colorado would like the idea of an employee only being able to access their pay information on a computer in their employer's on the employer's premises. So I think it requires an analysis of your workforce and making sure that electronic distribution is sufficient for your employees. But there's nothing in the COMPS order that prohibits electronic distribution.
All right, other question we have here. What are the differences between the Federal Portal Act in regards to travel and the new travel compensation definition under the COMPS order, COMPS 36? So under the COMPS order, the division wanted to expressly reject the Federal Portal to Portal Act amendments. Under the Federal Portal to Portal Act, that act narrowed the FLSA rights provided to employees in terms of travel time when they're moving throughout their workstations. And when reciting this rule, the division cited that no Colorado statute or Colorado rule has ever adopted language of the Portal to Portal Act that's similar. The travel time the travel time as provided under the COMPS order is aimed at two Colorado Supreme Court U.S. Supreme Court cases which were decided prior to the Portal to Portal Act, which prompted the passage of the Portal to Portal Act. And that's Anderson versus Mount Clemens Pottery and Tennessee Coal, Aisle, and Rail found. So if you look at those rules, it widens the amount of work time that can be compensated in travel time, and the Portal to Portal Act narrowed that. So the COMPS order is an express rejection of the Portal to Portal Act. All right, one more question here. Actually, we have a few more questions. Are the adjustments in January or July after 2020? So I'm assuming that this question is asking about the salary threshold. So the salary threshold takes effect in July 2020, except for January 2021, that salary threshold takes effect for only those specific employers that I discussed. So that's nonprofit employers with total gross revenue under $50 million and for-profit employers with an annual gross revenue under $1 million. But for all other employers, that salary threshold takes effect on July 2021. And then each year after that, it is changed in January 2021, 2022, 2023. And the reason that they have it, the salary threshold adopted in July this year, is to just permit more employers to have time to come into compliance with the salary threshold, because it is a fairly significant change. Here's a difficult question. What constitutes cleanup work? As Brooke discussed, the definition of timed work is extremely broad. So what constitutes cleanup work? I think cleanup work oftentimes is aligned with that traditional off-the-clock work, which Brooke noted, what is off-the-clock work? There's supposed to be no work that is done off the clock. So I think cleanup work is really just based upon the business of the employer. whatever that is, cleaning up your workstation if you work in a lab, or, your food preparation station if you work in a kitchen. Any type of work like that when it's connected to the duties that the employee has to provide and they're required to reside on premises and the employer permits that employee to perform those functions, that's going to constitute work time that needs to be, which needs to be compensated. All right, we have a couple questions here surrounding breaks. How do you enforce breaks? And what if the employee chooses not to take a break? So earlier this week, I was at a labor and employment conference where there were some representatives from the division who were answering these similar questions. And these are difficult and practical questions that employers face all the time. So I will relay to you what I heard at that presentation earlier this week, but it's obviously going to be an application that is based upon the particular circumstances of the employer. The employer needs to, in good faith, offer the breaks and provide the opportunity for the employee to take those breaks. If an employee simply says, if an employer simply says, you're entitled to take breaks, but the work conditions of the employee are such that the employee actually can't take the breaks, then that's not really offering the employee to take the break. The breaks need to be provided at those 4-hour sections of work, as I discussed earlier, and they need to be sufficient to allow the employee to go to and from the restroom, go get water, quick snack, and only in certain circumstances can the employer break down those breaks to 2 5-minute periods. Another practical suggestion, which I keep bringing up here, is the safety and well-being of the employee. So if an employee wants to continue to work through these breaks, then the employer needs to consider if this is going to constitute a liability for other employees on the job site. Again, I keep thinking about those examples with the construction workers because I know that was an important point addressed by the division. So I guess our best answer here is that you need to, in good faith, offer those breaks and require the employees to, or allow the employees to have that time off. And if the employee doesn't choose to take that break, then you need to address whether or not this is something you want to enforce in terms of safety, well-being, or measure your potential liability. If it seems that most employees are not going to be taking those breaks, perhaps you want to consider the circumstances in which you're offering those breaks.
And I think it's very important with respect to breaks that you make sure you have very clear policies that inform employees that they are expected to take the breaks. The concern here is the way that the COMPS order treats these missed breaks as unpaid wages. And so I think employers, have always struggled with what to do with the employee who isn't particularly compliant with breaks. But I think given the changes to the order, as Carissa suggested, you need to make sure that your policies are very clear and that you have accurate ways of tracking break time. There's several ways that we can do that. I'll throw out a couple of suggestions here in a minute. And I think the best approach is to make it as clear to employees as possible that these are expected. There's a question that had been posed, and then since it's on the same topic, we'll go ahead and discuss it with respect to how you track time on breaks. And that's a good question. There's, the safest way to do it. There's other ways that can be, perfectly acceptable. A lot of it depends on the policies of your workplace and the flow of the workplace and how difficult a time you have overall, making sure that employees take their breaks. The cleanest way to do it, particularly given the fact that it's a wage issue now, is to have employees clock in, clock out. There's, logistical difficulties with that, obviously, but that would be the safest way to do it because then you know for sure that your timekeeping system is tracking all time worked accurately. Another method that can be used is, again, make sure you have very clear policies with respect to the expectation, and then in connection with employees submitting their time cards or authorizing the accuracy of their time cards, you can include, an attestation to the effect that they received and took their, breaks for the week and give them an opportunity to identify any breaks that were missed. So that you'd have the option of going back and looking at those and compensating them if necessary. So that's just a couple of ideas. And again, which one works the best for you probably will depend largely on the logistics of your workplace.
Okay, so we have ton of questions on breaks, so we're going to continue to address these. When an employee is traveling, do they need to take a 10-minute break? Well, it's work time. If the employee is traveling as part of their work duties, then the employee is entitled to those 10-minute breaks. If the employee is traveling to or from the work site and that's not compensable time, so say they're traveling from their home to the job site, then they're not entitled to break time because that's not work time. But anytime the travel is classified as work time, then the employee is going to be entitled to those breaks. We have a question here asking, when would you utilize a meal or travel credit? Is that in place of a break or overtime? So credits are separate from breaks and meal time. So even though a meal credit is, I guess generally the same topic as meal breaks, they're two different issues. A meal credit is when the employer provides some wages to an employee in the form of providing a meal. The meal break, regardless of credits or not, the employee is entitled to a 30-minute unpaid meal break. So the two are, generally concerned meals, but they're two different topics here. And if the employee does take a meal break, that is not in place of a unpaid meal period. That is not in place of a paid break. The COMPS order specifically sets forth that meal times are different than break times, and employees are entitled to both the unpaid meal break and the compensated break times. Okay, in a previous COMPS webinar, it was mentioned that job postings, even if promoting internally, had to be posted including salary information, regardless of the job level, prior filing position. Did this make it into the final regulations? I don't remember that topic being covered in the previous COMPS presentations. Brooke and I both. You got it?
Okay, yeah, so this was a slightly different presentation. We've had a couple of changes in Colorado law. One is the COMPS order. The other one is the Equal Pay for Equal Work Act, and the legislation focused on wage transparency. So this is an issue that came up in the context of equal pay for equal work. Different law. And yes, the posting requirements that were discussed in that webinar, in that seminar, did become law in the state of Colorado. So the postings that include salary level and all that information that we discussed is law in the state of Colorado, but that's under a different statute. It's not under the COMPS order.
With the definition of employee changing, how does that affect us with an employer who works mainly with independent contractors and subcontractors? Is there any additional documentation to prove that they're independent contractors versus employees? So what's important to remember is that this COMPS order only covers employees. It does not cover independent contractors. Really, the definition of employee doesn't seem to impact the calculation of who's an independent contractor versus who's an employee.
Yeah, that's correct. The independent contractor test in the state of Colorado is not affected by the COMPS order. The COMPS order only kicks in if you're in the unfortunate situation of having somebody that you've treated as an independent contractor reclassified as an employee. So this applies to your employee workforce.
All right, here we've got a specific citation to the COMPS order, so I can see some folks are following along at home. So let me flip to that portion. All right, COMPS rule 2.5.1, now this concerns salary threshold for certain exemptions, states 29 CFR Part 541, Subpart G apply except ... The salary requirements of Subpart G include the specific salary exemption for administrative academic employees. Does COMPS 36 still uphold the salary exemption for administrative academic employees? Yes, administrative employees under the COMPS order are one of the subgroups of employees that are required to earn the compensation set forth, the salary threshold set forth in Rule 2.5.1. As I noted earlier, the administrative employee exemption under COMPS is slightly different than it is under the FLSA. However, there is some common language. So this question here concerns administrative academic employees. Under the COMPS order, the definition of administrative employees are those, as I noted, who directly serve the executive, which is different than under the FLSA, but they also must regularly perform duties important to the decision-making process of the executive. The employee must regularly exercise independent discretion and judgment as to matters of significance, with a primary duty that is not manual in nature, and it must be directly related to the management policies or general business operations of the employer. So you can see that there are some similarities between those two, particularly the exercise of independent discretion and judgment as to matters of significance. And there's actually a significant amount of federal guidance on what those terms mean. So as you can see, that the administrative exempt employees are still entitled to receive that overtime compensation. And we did have one question concerning 501c7s. We do not know the answer off the tops of our heads here, so if you want to send us an email, we can happily answer that particular question about 501c7s. And with that, it seems that we've answered all the questions that we have here. Oh, it looks like we just got another list.
Have a couple more minutes.
Thank you for your active participation.
We'll try to squeeze in a couple more questions, and we'll take a look at what we have left over that we haven't had a chance to answer, and see if we can get out some sort of supplemental communication that might help answer some of these questions if we're not able to get to them. So we have a question: do you have to include all poster language in the handbook? The answer is yes. That's the way the COMPS order reads. Of course, the poster is available online, so hopefully it's simply a matter of taking that document and inserting it as is into your handbook. We have a question about how is the language of the FLSA computer exemption different from the one in the state of Colorado? They're fairly similar, but there are two additions to the computer exemption in the state of Colorado that are not in the language of the FLSA exemption. In the state of Colorado, the computer exemption requires, in addition to the skills and the job duties that the person is performing, that person has acquired them through a prolonged course of specialized formal or informal study. So it's essentially the same kind of requirement that you find in the professional exemption that requires essentially, as it has been interpreted under the FLSA, the equivalent of a four-year college degree. There's also a provision that requires that the person be spending a minimum of 50% of the work week in performing certain types of tasks that are outlined in the COMPS order. In the FLSA, that is not handled as a 50% requirement, but rather as a primary duty requirement, which of course can have a slightly less specific interpretation. So those are the general differences. Of course, if you have a specific person or job you'd like to look at or analyze, we're certainly happy to help you with that.
All right, one more question here. More questions, sorry. I keep saying one more because it's just a crutch phrase. How are you advising national employers regarding the handbooks? Do you think the policy needs to be actually incorporated into the handbook, or can it be handed to the Colorado employees when they receive the handbook? It can be handed to the Colorado employees when they receive the handbook. Obviously, employees in other states don't need to receive the COMPS, poster COMPS notifications. But practically speaking, if you hand it to the employee in addition to the handbook and say you require the employee to sign the handbook, the employee is also required to sign and acknowledge receipt of the COMPS order as well. So it can be, an additional amendment to the handbook and needs not be distributed to employees who are not covered under the COMPS order.
Correct. It may be simpler just as a logistical matter for Colorado employees to just include it in the handbook. I think it's probably clear from the intent of the regulation that they need to be found together. So if somebody was looking for the handbook, whether it be hard copy or electronic, I think it's presumed based on the language the COMPS order needs to be with it. But to Carissa's point, it obviously does not need to be distributed to employees who are performing work outside of the state of Colorado, because that is the definition of coverage for purposes of the COMPS order. Okay, we're running up on our hour. Thank you all. Again, thank you all for your patience as we're attempting to structure these things to account for current events. I'll let you know that we have made the decision that we probably will not go forward with the Colorado seminar this year because of the virus issue. It's the first time in its 40-some-year history that we've had to cancel. We will be keeping you informed on whether or not we're going to be able to reschedule it for this year, whether it will resume it next year at its regular time. So we're very sorry about that, but we'll keep in contact. What we will do is we'll make an effort to put together some sort of communication, either individually if we can track the question, or more comprehensively for those questions that we did not get to, and get that out to you. And please try to pay attention to our blog and our website. We try to put out client advisories and blog information on a regular basis in the best of circumstances, but particularly given current events, we're certainly going to attempt to use those resources to provide even more information to you, since the chances of us being able to visit in person are not so good at present time. So thank you all again very, very much. Feel free to get a hold of either one of us if you have questions that you didn't have a chance to ask, or if you have follow-up questions, and we're happy to help. Thanks again.
Thank you.